My Lords, with regard to the new prescription point,
Yes.
Mr. Scott and I would propose that we exchange written submissions by the 18th of December, and we're told by your registrar that it would be possible to relist the matter for the 25th of January. So I hope that that would meet with your approval too.
28 days seems reasonable in the circumstances, yes. I must say. 25th of January.
Yes, well, we'd hope to get it done by the end of this term, effectively. 25th of January it was. Yeah.
What about a short reply? I think each party will give an opportunity to put in a short.
Yes, Lord Clerk makes a very valid point that it would probably be sensible to have a provision for replies. Say by the 14th of January?
Yes.
I plucked that figure out of the date.
Certainly.
Out of the hour.
Well, the reason we suggest exchange is because that's what we've done so far,
Yeah,
but indeed
right.
it would be helpful to have replies.
I'll say the 15th, which is the Friday.
Yeah.
Yep. So that's the line for the Christmas period. Yes, okay.
Yes, well, there's one matter which I hesitate to refer back to, but you'll recall that my Lord Hodge asked me about my client's state of knowledge in relation to the rumours in Margaret Underwood's declaration. And your Lordships made the observation with which I respectfully agree that it's somewhat unsatisfactory to deal with it in this way. But the matter...
I'm not asking you to.
No, well, my Lord, the difficulty is that my client heard what you had to say and is very anxious that I shouldn't leave the matter hanging in the air. And I wonder if I might be permitted to say that my instructions are that his father had never mentioned the matter to him at all. My Lords, before the short adjournment, we were at page 58 of the bundle, which was the reaction of Sir Stewart to the DNA result. It seemed to me that your Lordships would probably not get any help from the subsequent correspondence between the Standing Council of the Baronetcy, Simon Watson and Sir Stewart. It is in the bundle, but I wasn't proposing to refer to it at this stage. Again, I also thought that it would probably not be necessary to refer your Lordships to the DNA evidence in any detail. It's there, and I think its effect is not disputed. There was one curious...
If there's any dispute about it, the effect was summarised to you, I think, by Lord Hughes or Lord Clerk.
Yes.
If it's not in you're in difficulties, if it's in your home, and that's your case.
Yes. There was just one small feature which I noticed reading up for today's hearing. And I didn't want to leave this lying in the air either. One of the persons who took part in the surname project was actually Greenaway. I don't know if you remember that name.
Yes.
Greenaway.
Yes.
He is descended from an earlier illegitimate child of Florence Madge Vaughan. And I wondered how he had come to be included. The answer to that is that he had apparently been engaged in his own genealogical research and had found out that there was a Pringle connection. But he was not someone who'd ever communicated with my client before. Just on that question, Kate Greenaway, in case your Lordship should also wonder, cannot, I think, be the same Kate Greenaway who
was the famous illustrator.
The famous illustrator, because this one, or that one, the famous illustrator died in 1901. I thought it must be, because I thought it was an unusual name, but in fact it's not the same. My Lords,
Could I just ask Mr. Guthrie whether we know? I expect we do, and it may be that we don't need to anyway. But there are various in Mrs. Pope's report on the DNA. There are various other Pringles referred to, other than those who are familiar to us as on one side or other of the immediate family. Do we know who those are?
I think on the whole we do.
Well, it may not matter.
Well, if you have the correct version of my case, it should have at the end of it two family trees. And those family trees indicate who was tested and who wasn't. I think I can find it. At the very end of the case, there are two family trees. The first one, family tree of Pringle of Stichill.
Yep.
That starts at the top with the 8th baronet.
Yep.
I'm sorry, no, it starts at the top with the 7th baronet. The 8th baronet is on the left.
Yeah, no, we've seen that, and please don't take time
I think
taking
if
us
you
through
look
that.
at the individual entries, under each entry, where there has been a test,
Yep.
there is a box
Yes, there is.
with Y-DNA test result. So that should
As a matter of interest, I mean, I don't understand the boxes at the top right because they don't appear to correspond with any gradation of colour or coloration in the main charts. But
well, I'm afraid that may be because you haven't got a colour. Have you not got a
no,
colour?
we haven't got coloured ones.
Those could be provided if necessary.
Might be helpful.
Yeah.
Can you just help me? How do we know that the right-hand larger block, which has more DNA testing in it, but nonetheless only from 2 stirps, I think, how do we know that that is, in other words, coming through Ronald Stewart Pringle and the other one through Norman Robert Pringle?
James Drummond.
Yes, sorry, James Drummond Pringle,
the
quite
brother.
right. How do we know that that one is the actual result of the marriage of Norman Robert Pringle and Florence Madge Vaughan, rather than the left one? Is it just because 2 is stronger than 1, or what?
Well, I think it. Yeah. Well, I think it's explained in Susan Pope's report. I have to confess that I get very, very muddled when I'm trying to.
Well, she certainly does take
Yes.
that point,
Yes.
namely that you would have to postulate 2
Infidelities with,
Yeah.
I suppose, the same person or very similar purpose. Very,
And
very
the
closely
two
related.
persons who are out on a limb
Yes.
are in the left-hand box, and indeed.
Well, 3 persons.
3
actually.
persons. Well, the third person, I haven't troubled you with this because it's not going to assist, but he accepts the situation and his.
Yeah, we've seen the
You've seen he's got
material.
a statement in that.
But no, that I'm afraid is the reason why I asked the question. If it's all agreed, it doesn't matter. We
Well,
don't
I
need to
think it
trouble
is
ourselves.
as far as I know, it is all agreed.
But at 345 in the record, Mrs. Pope lists the various people who are associated by the DNA with what Lord Mansus conveniently called the right-hand side of the page.
Yes.
And some of them are obvious because some of them are in that box, and the others, at least unless I've missed it, aren't. And if they are, as it were, control members of the Pringle family, then you can understand the force of it. And but otherwise, it raises precisely the question that Lord Mansus just asked. Perhaps I'm wrong.
Well, I have assumed that I needn't trouble your lawyers with the detail of it because it's not suggested that the result is not as I've suggested it is.
Do we find this as perhaps the discussion at, particularly at 354, onto 355,
Yeah.
Yes.
where she starts looking at DNA from Pringles who are outside the immediate family?
Yes.
Well, we know something about some of those. One's in Australia, one's in the United States, and some are referred to elsewhere, and 2 of them aren't, as far as I can tell. But it still begs the question, as it were, if they're controls, how is it established that they're controls? But maybe it is.
Well, Lords,
All right.
I'm anxious not to involve.
No. Right, thank you very much.
I was going to
I mean, she does make the basic point that I made, two against one, but then, as Lord Reed points out, she goes on to draw on some other controls.
Yes, and it's perhaps worth pointing out that she's not alone. She also refers to the consideration of the matter by Professor Watson and Mr. Clayton.
Well, he simply
Yeah.
identifies the two
Yes.
strands.
Yeah.
Doesn't help on the other question. Right. Well,
Well, the
Yeah, so that somewhere we've got more material which she's drawn on about these other A to F controls.
well, I was going to just take up the question of the circumstances in which the sample was obtained. You've seen the letters written by the parties and by the laboratory in July and thereafter at the time. The point which we have made is that, in fact, there was no sort of formal complaint as such as to what had happened from Sir Stuart until March 2012, and it came in the course of the correspondence with Sir Simon Watson. And the letter is at page 321. When he says he does not wish to take another test, despite Mr. Murray Pringle's very generous offer to pay for it, the second time he has exhibited or displayed similar generosity for a similar purpose, me. The following are the reasons for decision. One, I freely gave Mr. Pringle access to my DNA shortly before he wrote his letter to me claiming the title. Two, when asking me for that, he claimed it was only to check that I was a proper person to be clan chief of the Pringles, an offer that I had already declined as I felt too old for it. In fact, the two above courses had raised my suspicions that all was not quite what it seemed. Thirdly, that a baronet shall be a man of honour by birth, if not by merit. And I believe in these circumstances Mr. Murray Pringle does not qualify. Therefore, I would not willingly do anything that might strengthen his claim. We have submitted in our case that that wasn't an entirely fair letter. One can understand some upset on behalf of Sir Stuart, but what he suggested is not borne out by the earlier correspondence, which I've taken you through, and I don't think I need go through it in detail again. He also swore an affidavit in an application for an injunction, which I think was never heard, which is at page 265 of the bundle. And it begins at page 261. In which he made certain complaints. In paragraph 13 on page 265 at the top, he says he must assume that the applicant had opened the pages for me, presumably in his capacity as administrator of the Pringle surname project. Secondly, that he was at all times able to access my personal pages on the DNA Heritage website. It should be noted, however, that at no stage did the applicant seek my consent to his access to these pages. Well, my lords, that we submit was inaccurate because it had been made entirely clear in the correspondence that the applicant did have access to the pages concerned. And the same, a similar complaint made in paragraph 16 at the foot of the page. He says he assumes that it allowed the applicant to obtain a copy of my report and certificate from DNA Heritage, which report is exhibited to the applicant's witness statement in support of these proceedings. I should emphasize, however, that I personally did not provide the applicant with a copy of this certificate. I am also advised by Simon that he did not provide a copy to the applicant either. The applicant must therefore have obtained it without my consent in his capacity as administrator to the Pringle surname project. Really, the same point is made again. It had been spelled out in the documents at the time that the applicant would have access to the pages and see the status of all the participants. In paragraph 19, Sir Stewart says, I believe it's clear that I only gave consent to use my DNA for the purposes of establishing a clan leader, Pringle. There was no question of the applicant using it for any other purpose or suggestion that it would be so used. Therefore, clear that the consent was on the understanding that it would only be used for this purpose. In the proceedings, the applicant seeks to use an analysis of my DNA for the purpose of seeking a declaration that my father was not the son of the 8th Baronet. It was, with respect, very much an oversimplification of the situation which had existed when he gave his consent. I've shown you the letters, but they did refer to not only the application of the clan chief, but also providing a genealogical database and to access by the applicant and so forth. They did refer to the possibility of the use of the results in evidence before the Lord Lion. And it's our respectful submission that it was a little unreasonable to suggest that the applicant was, so to speak, restricted to use of the sample only if it supported Sir Stewart's claim. Of course, at that time, it was not foreseen that anything like this would happen. Sir Stewart did give his consent on the basis of the documents which were put before him. And indeed, it was said that it was at his request that the DNA was analysed. That's the format which was used in the letters to him from DNA Heritage. Obviously, he was taken aback by the results, but it's noticeable that even at this stage in the affidavit, he does not complain about disclosure of the material to the Lord Lion or to the Registrar of the Baronetage. We respectfully submit that my client really has nothing to reproach himself with, and so far as what took place, took place. The claim for breach of confidence, we say, is largely answered, if not completely answered, by the fact that Sir Stewart did give consent in the circumstances in which he did give consent. So far as disclosure is concerned, the Data Protection Act is quite a difficult act to follow, but the fact is that nothing my client did can possibly be construed as a deliberate attempt to breach the terms of the Data Protection Act. And if there was some technical breach, we would submit that it is certainly not something which would lead to the result that the evidence became inadmissible thereafter.
Your argument amounts to this, does it, that when considering whether to allow this in, A, properly analyse whether under the Data Protection Act or under confidentiality or even some sort of inherent jurisdiction of the court, you say there are no grounds for not allowing it in, but even if there are grounds for allowing it in, they are outweighed by the interests of establishing the truth.
Well,
and that's the right approach.
That's the way we put it, and indeed
the latter way is the right approach and principle. Is it a balancing exercise? Do you say?
Well, I think so, my lord. Yes, and in fact, I have expanded that in rather more detail in writing.
Oh, yes,
it won't be helpful to say it all again.
And
there is one point in relation to the Data Protection Act, though, in section 35 of that act.
Yes.
Which your lordships will find, I think, at page divider 28. I'm sorry, I'll just give you
Yes,
the reference.
section 35.
Section 35, which is at page 1653 electronically. Which exempts disclosures required by law or made in connection with legal proceedings, etc. Personal data are exempt from the non-disclosure provision where the disclosure is required by or under any enactment by any rule of law or by the order of a court. Section 2, subsection 2, personal data are exempt from the non-disclosure provisions where the disclosure is necessary for the purpose or connection with any legal proceedings, including prospective legal proceedings, or for the purpose of obtaining legal advice, or is otherwise necessary for the purposes of establishing, exercising, or defending legal rights. The disclosure which was made by my client was limited. You'll see that he copied the letter he wrote to Sir Stewart to the Lord Lion and the Registrar for the peerage, baronetcy, and so forth. And if he is correct in this matter, the baronetcy is his legal right.
Yes, but nothing required this evidence to be available to enable him to establish his legal right.
Well,
And the question is whether he was entitled to use the information which contained private data, that involving a type of disclosure, and this only deals with situations where some law required him to do that, but nothing required him to breach or to use private information.
2, not 1.
no, but subsection 2 doesn't.
Oh, subsection 2, yes.
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 I mean, he would say, I think reasonably, that disclosure was necessary for the purposes of asserting his right to the baronetcy.
Isn't that the same point? I mean, it wasn't necessary for him to have this evidence. Was it?
If he wins.
But could you turn it on its head and say if the court decides it needs it or wants it, if the court thinks it's otherwise appropriate, you say what Section 35 does to put it to the lowest is not to prevent the court, the Data Protection Act is not a reason for refusing disclosure if the court otherwise thinks disclosure is right.
Well, it could be put, that's another way of, that's another consequence of the section.
Because of the reference to order of the court.
But
That doesn't beg the question about whether the court takes into account data protection considerations.
But I would very respectfully say that this is a case in which one is a long, long way from the kinds of consideration which your lordship had to consider with in Immerman and Cengiz. If there was a use which wasn't contemplated or wasn't, it was not deliberate or an intention to breach the Act. And it is not a matter which should lead to the exclusion of evidence where justice requires that it be admitted.
Thank you.
My Lords, I said I would be half an hour. I think for the moment, unless there are some particular matters.
Thank you very much indeed, Mr. Guthrie. Thank you. Mr. Scott.
My Lords, my Lady. Lord Brown-Wilkinson sometimes used the term macro issues, and I would suggest that may be helpful here, and that the many different issues in this case can be divided, or one might say bundled, into 2 macro issues. The first macro issue, I suggest, is whether, leaving aside for this purpose all the issues relating to the misuse of private information, Murray should be entitled to rely on the DNA evidence. The second macro issue is whether, assuming that he might otherwise be entitled to rely on the DNA evidence, he should nevertheless be precluded from doing so because of the misuse of private information issues. Now, taking those 2 macro issues, my Lord Reid this morning raised the question of Scottish prescription law, and that clearly falls within the first macro issue. My Lord the President canvassed the idea that the hearing today might be limited to what I've now categorised as the second macro issue. That is not, in fact, how the case has developed during the course of the morning.
Quite right.
What I propose to do, if this is convenient for the board, is, in the light of the fact that we will be putting forward further material about Scottish law, to leave to one side for the moment all matters relating to Scottish law, because I would have had a number of comments to make about the two Scottish cases which have been cited, but in the light of further and better information about Scottish law, I may have more or fewer or different points to make, so it seems sensible not to touch on that at all, and I will keep my powder dry in that area. My Lord, the first macro issue requires us to consider really what this is about. And what this is about is that, prima facie, and throughout his life, the 9th Baronet, Sir Norman, regarded himself and was regarded as the legitimate son of the 8th Baronet. If he was the legitimate son of the 8th Baronet, he was entitled to become the 9th Baronet. I shall be seeking to demonstrate that the great emphasis which my learned friend seeks to place on biological descent has been greatly overstated, and that when one looks at the wider picture, then in fact what one must focus on is legitimacy rather than biological descent. And the starting point for that, and I don't mean to go to the Ampthill case straight away, but there is a short passage from the speech of Lord Simon of Glaisdale in the Ampthill case, which we rely on in our case, which says in terms that one of the incidents of legitimacy is the right to inherit a title of honour. And I say that we don't need to go beyond that. So I do stand by the formulation in our case about what the issue is before the board.
But legitimacy involves as biological descent as a sine qua non. The fact it may be difficult to prove, for the reasons that we've been canvassing, is one thing, but you can't be the legitimate child of X unless you are the child of X. The question of legitimacy is a question of your status.
Well, my lady, yes. I say yes. Yes, a qualified yes, and I will come back to that. At the moment, I'm merely trying to define what the issue is, which we say is the issue before the board. And we say that the issue is one of legitimacy, and I leave aside but I will be spending a considerable amount of time on the question of how legitimacy and biological descent have to be seen in relation to each other.
Can you summarise?
Yes. In summary, my lord, the position is that certainly throughout English legal history, then a very blind eye has been turned to the question of biological descent. So my Lord Reid raised a question about whether a child who is not the biological child could be acknowledged. My lady gave what is unquestionably the correct legal analysis about that. But what I shall be seeking to demonstrate is that as a matter of practice, over many centuries, the courts have adopted procedures quite consciously and deliberately, which have in fact blurred that question and have made the practice one where parents have been able to acknowledge, because it was made impossible for anyone to challenge that acknowledgement if they chose to acknowledge. So I shall...
Impossible as a matter of fact.
Impossible as a matter of law and fact.
Well, certainly the rule which was applied in Russell and Russell is an example of what you're talking about.
It is.
Yes.
It is.
Countless children of the mist.
Yes.
As it has sometimes been expressed, yes.
And
but usually after the first heir.
Sorry, after, you mean...
After the first male heir.
Yes. Yes.
After that it was tolerated.
But what we have done in our case is to develop what we say are the policy reasons behind this, namely that particularly where you were dealing with what was known as adulterine bastardy, it would have been extremely destructive to allow these issues to be raised, except in very limited and special circumstances. And so the law developed in a way which made it extremely difficult to raise these issues. There were, and we say still are, very sound policy reasons behind that. Because even though nowadays the stigma of illegitimacy has largely been removed, it is still immensely destructive of any family and by enlargement of society as a whole, if and when it is learned that a child of married parents is not, in fact, the child of the husband. So the policy considerations, we say, still apply with great force. The wider significance of this, the potential ramifications, are illustrated by the story of the identification of King Richard III. We have included in the bundle the paper by the geneticists who carried out that research. We can't necessarily look at it, but I think it's a story which can be told. My learned friends already touched on it. The short point is that the identification of the remains which were found in the car park in Leicester was achieved entirely through mitochondrial DNA, which runs through the female line. When the geneticists examined the Y chromosome DNA, which, as we know in this case, runs through the paternal line, it was found that the subjects who are unnamed members of the Duke of Beaufort's family could not show and were plainly not descended in the paternal line, although they demonstrably were in the maternal line. Now, we don't know, because of course confidentiality was rightly observed, whether any title might have been put at issue if that research was followed through to its logical conclusion.
I thought it went back to the link to prior to Richard III.
There is a link prior to Richard III, but of course bearing in mind that the respective family trees have crossed at more than one point, it would require an enormous analysis to demonstrate what that means. But it does show that even in the grandest families in the realm, there are what Sir Stuart referred to as cuckoos in the nest. And my learned friend naturally deprecates, as one would in his position, the use of the floodgates argument. And of course, I wouldn't put it so crudely. But what I do say is that the potential ramifications of allowing DNA evidence to be used to upset well-established lineages are potentially very wide-ranging, and that as time goes on, it is likely that the reach of DNA evidence will increase, and therefore the potential for disturbing lineages will increase with it.
This is a sort of interiorem point.
It's not exactly, my lord, but we are dealing here with public policy questions, and I say that this is a factor to be weighed in the balance in the overall public policy decision.
So at what point should courts show a disinterest in the truth?
At the point where one whole generation has lived and died being regarded as legitimate. Here, in this case, the 9th Baronet. And I shall be citing authority in direct support of that.
Thank you.
So up to, what, 1961, is that right?
Yes.
Yes.
Can I ask, are all titles in the same position? I mean, we're dealing here with a title of honour.
Yes.
And other than the honour of holding the title, there are no other ancillary implications.
No.
I mean, you mentioned the Duke of Beaufort, for example. Would a dukedom be in the same situation as a baronetcy for these purposes?
I can't see why it wouldn't.
Sorry.
I'm sorry, my lord, subject possibly to the point which learned friends said about the 1910 warrant, but with respect to that, I would say that that warrant was never intended to and cannot possibly be given the effect of disturbing the established rules concerning legitimacy and succession to titles. It was essentially a procedural matter intended to provide a proper record of those persons who are entitled to be baronets. And the possibility of correction, I suggest, was intended probably on a fairly short-term basis, so that if anybody who was intended at an early stage when the role was established was put forward a claim and was enrolled, and then, say, a few years later, somebody comes up with a better claim, well, then the role could be corrected. But it cannot open the door of itself to claims which are made 50, 100 years later.
So can I just get your submission right, or the submission you're going to make? And that is that up until the moment of death, 8th February 1961, the title could be challenged, but as soon as Norman Hamilton Pringle, the 9th Baronet, as he was called, died, it can no longer be challenged.
My Lord, yes. I mean, there might possibly be a grey area that if on his death a challenge were made, possibly. But my primary case is, as your Lordship formulated it.
Yeah.
And that's based, a pragmatic rule based on authority or a principle or what exactly?
It's based on authority, but it also coincides with common sense and wider considerations of public policy.
Well, perhaps we better look at the authority and see for what proposition it's authority.
My Lord, yes. We're coming to it very shortly. Let me turn to the authorities. Can we perhaps start? Both Maloney Friend and I have referred to the 1838 textbook, Nicholas on Adulterine Bastardy. If we can start with, well, we're coming back to that, but if we can start with one short passage from that. It's at page 1760.
Thank you.
And it's divider 41 in the second authorities bundle.
Yes. We don't have the front page.
Is that really its title?
It is, my Lord.
Yes, you can see that from yes.
It is. And indeed, it's available in facsimile edition, and which we have.
I don't suppose it's in print.
But yes, I'm afraid that the first page, page 249 from the book, is before the divider. But we can see that that's page 249.
But we don't have the title page.
No.
Of the book?
Yeah.
No, but we can bring the book itself tomorrow.
Thank you.
Yeah, if you could photocopy the title page.
I'm sorry, my Lord, yes.
No, it's always comforting to see it. Thank you.
And
Particularly
what
with
has
this
happened
title.
is that the author has gone through an elaborate history of the leading cases on the subject, from which he then sets out, I think, 14 propositions, starting with the earliest times, and we don't need to go through all of them, but it's proposition 1, we see the earliest period any writer on the law of England flourished. 2, he moves on to the 13th century. 3 deals with the next legal treatise of Britain. Then at the top of page internal page 250, still dealing with the early period in common law, he says, as the common law applied the term mulia to describe children who, though legitimate de jure, were not begotten by the husbands of the mothers, it always contemplated the possibility of a succession to the husband's inheritance by persons under the character of sons and heirs who were not begotten by them, for the purpose of preventing uncertainty, litigation, and the chance of committing injustice towards innocent parties. So this is why I say that my proposition goes back into the mists of legal history. And then just to give the context, if we go on to page 253...
And who are the innocent parties?
I'm not clear, my Lord. I presume innocent parties would be persons who had acted on the assumption that the person was entitled to inherit.
Or their children, perhaps.
Or their children. Yeah. I think it must mean that.
Well, it's a mitigation of the rigour of the consequences of being illegitimate, which are never the child's fault.
My lady, yes, but it's a very substantial mitigation, and
I'm not suggesting it's not.
It goes right back.
Yeah.
So then it's 13 propositions. They come to an end towards the foot of page 1764. And the author then continues, the preceding brief summary brings the history of the law of adultery and bastardy down to the year 1706. And he then picks it up from there. If we can now please go to the first authority that we'll be looking at, which is in Authorities Bundle 1, page 1206. This is the Purbeck barony case. And as with a number of these cases, the facts extend over a long period of time and are extremely convoluted. But in brief summary, and I hope this will spare us having to go through many pages, in about 1630, Lady Purbeck gave birth to a son in circumstances which were unclear, probably at the time and certainly afterwards, but certainly there was a suggestion that she was living with a man other than her husband. That son, who was known as Robert Wright, sought to distance himself from the Villiers family, the Purbeck family, and this is very unusual, he specifically tried to avoid taking the Purbeck title. And indeed, he was summoned to the House of Lords, who tried to insist that he should take the title, and he tried to refuse to do so. And in the end, he ostensibly surrendered the title to the Crown. But if we can pick the story up at page 1218.
Where is this coming from?
This is, in fact, an extract from Nicholas on Adultery and Bastardy.
It's another extract.
It's another extract, yes. It's the best report that we could find. So, if we pick it up at the bottom of page 1217, it says, the fine was levied and the honours of Baron of Stoke and Viscount of Purbeck, as well as the remainder, etc., were considered to have been legally surrendered to the Crown. Right. So then the son, the person we've been speaking about, died, and his grandson, his son, that's to say grandson of the original Lord Purbeck, petitioned for the Purbeck title. And the issues before the Committee of Privileges were first whether the surrender of the titles could have been valid, and if so, whether they bound a descendant, and secondly, whether his father had been the legitimate son of his grandfather, bearing in mind the mysterious and unclear circumstances of his birth. So, if we go, please, to page 1231, at the bottom, the final paragraph, Lord Finch, the Chancellor, in delivering his opinion, observed, the question whether there be a legitimate succession to this honour is a question of fact, wherein the doubt is not whether the petitioner be legal heir to his father, but whether the father were so to his grandfather. And therein it is admitted that the father is legally the son of the grandfather if he can prove himself the son of the grandmother, and this fact is now called into question. I was pausing there. The opposition didn't feel able to challenge, under the rules then in force about bastardization, didn't feel able to challenge that the father was the grandfather, was the son of the grandfather, so they sought to challenge that he was the son of the grandmother. But Lord Finch had none of this. He says that this fact is now called into question, and the grandchild, after 50 or 60 years elapsed, is put to prove not that his father was lawfully begotten, everyone sees the danger of that, but that which is all one in consequence, that his father was begotten of his grandmother. This ought not to be endured, for, first, filiatio non potes probarim debet, paternity cannot be proved, nor should it have to be. 2, it tends to defeat purchases made of the father as heir, etc. 3, he hath been found heir to the land. Well, my lord, that's probably not relevant. 4, this should have been questioned, if ever, in the father's life. For he that is a bastard, as being born before wedlock, yet if he die with the reputation of true heir, he cannot be bastardized afterwards, but his issue shall carry away the land from the legitimate heir. And then 5, the rather splendid observation, strange questions are sometimes raised for crowns where armies dispute, but where a coronet only is at stake, it is not to be suffered.
We have Littleton on dissents.
Yes,
I'm sorry, my lord?
Do we have Littleton on dissents?
My lord, we don't, I'm afraid, no.
I think we'd better have a look at it.
And, my lord, that is the authority, we say, for the proposition that if somebody has inherited, has lived and died, and passed on to his heir, then that cannot be challenged. He cannot be bastardized posthumously. My lords, the next case is back to bundle 2 of the authorities, page 1613. And that's divided 27.
thank you. Yes.
Now, this is another extremely complex story concerning the Willoughby of Parham title. If we can pick it up in the right-hand column on 1613, then we can see that just over halfway down, that, well, perhaps I can just summarize it and your lordships can go back to look at it in more detail. But a Lord Charles Lord Willoughby had 5 sons, and Henry, the son of Ambrose, who I think was the second son, went to live in Virginia, where he lost touch with the family. So the senior Stirps became extinct, but he was aware of this, and he failed to make a claim. So in his absence, the title passed to a line or Stirps junior to that of Sir Ambrose. So then, many years later, in 1733, Henry's grandson, that's Henry the son of Ambrose, who had gone to Virginia. So Henry's grandson, Ambrose's great-grandson, also called Henry, petitioned the lords to take the title. And we can see this at page 1614. In the left-hand column, we don't need to go through his petition, but we can see that this was, his petition was presented in 1733. Now, at this time, the title was held by Hugh, who was the descendant of the junior line or Stirps. And so, therefore, if my learned friend's approach was strictly accurate, then Henry would have been entitled to say, well, there's been a terrible mistake, My family have been living in Virginia for the last 80 years. I've now come out of the woodwork. I am descended from a senior stirps to that of the present ostensible incumbent, and therefore I am entitled to take the title. But what in fact happened was that his petition was apparently never put before the House of Lords. And it went to sleep for 30 years until in 1765, Hugh, the then Lord Willoughby, died without issue. So at that point, the junior line, which had come into the title because of the absence of the intermediate line, as I'll call them, in Virginia, that junior line was extinct. And so Henry, great-grandson of Ambrose, presented a fresh petition, which on this occasion was put before the Committee for Privileges. And one point, perhaps a small point, but perhaps worth looking at, is we can see his petition starting at towards the bottom of the left-hand column on page 1614. And he goes through the genealogy, which I've tried to summarize. But if we see on the right-hand column, opposite where the name Henry Willoughby is printed in the left-hand column, then the petition reads that your petitioner is now the heir male of the body of the said Sir William Willoughby Knight. So he was putting his claim in 1767 on the basis that he was now the heir male, whereas on the strict view for which my learned friend contends, he always had been. And we can see the outcome on page 1615. Starting in the middle, it's Friday the 20th of March, 1767. It deals with, it says the Lord, I think it's Botcourt, reported from the Lord's Committee for Privileges. And he sets out the history. And then about 12, 15 lines from the bottom of that column, it reads as follows. It now appearing that Sir Ambrose Willoughby, the second son of the said Charles and elder brother of the said Sir Thomas, who was averred to have died without issue, left a son, and that the now claimant is great-grandson and heir male of the body of such son, and consequently heir male of the body of the said Sir William, who was created Lord Willoughby of Parham, the male line of the eldest son of the said Charles, having failed in or before the year 1680, and that the proof of the petitioner's pedigree being clear, the contrary possession ought to be no bar to his claim, as there is now no person in being interested under such possession, without prejudice to the question if there was. So this, we say, is extremely important because one doesn't really have to read between the lines to see that the House of Lords refused to countenance his petition during the lifetime of Hugh, notwithstanding that he ostensibly, as a matter of strict law, had a better claim than Hugh. On Hugh's death...
Well, where do we get the conclusion that they refused?
My lord, I say, reading between the lines, that they didn't, and it's hard to think why otherwise they wouldn't, because it must be the natural inference that within a year or two of Hugh's death, a fresh petition was heard.
This can't stand with the Dunbar of Kilconcy in the Lord Advocate case, then, can it?
Well, my lord, I was saying I wouldn't deal with that today, but...
They accepted it, didn't they?
Who?
Now they accepted it.
Yes.
Yes, that's the bottom line.
Yes.
So it went to sleep for as long as the other chap was the incumbent, which may or may not have been tactical. And then there was a fresh petition And he got it.
And he got it, but he got it expressly without prejudice to what the position would have been if Hugh had had issue.
Absolutely. Well, I think the word without prejudice cuts both ways.
Well, my lady, it should cut both ways, yes. But I would suggest that the natural reading of this case, looking at it as a whole, is that he did not get heard until after Hugh had died without issue. One must seriously question whether, if Hugh had left issue, he would ever have been heard.
And what they're saying is without prejudice, that question, they're leaving it open. It's
Yes.
neither one thing nor the other.
Well, on your interpretation, the Kilconzi case must be wrong.
Well, my lord, I'm reluctant to go into the Kilconzi
No,
case.
but I mean, it just seems to me, if you're suggesting that this case establishes validity in an invalid line, pro tanto, then wouldn't that throw doubt on the Kilconzi line of reasoning? Someone could pop up after. Anyway, maybe we'll forget about it. The question probably turns on without prejudice.
It's a good example of a pragmatic solution to a problem.
Yes.
Which ended happily for all concerned.
Yes. But it also, on the way to that, it casts doubt on the biological supremacy law for which my learned friend contends.
As was members without prejudice.
Well,
But you're not going to you're proposing to deal with Dunbar Kilconzi tomorrow.
my lord, I was proposing not to deal with it tomorrow on the basis that it falls within Scots law, and therefore I was proposing to deal with it when we return in January.
When you do, can I suggest that you might also look at a case called Bosville against Lord MacDonald, which is reported in 1910 Session Cases, page 597, as there's a passage in the opinion of the Lord Ordinary, Lord Skerrington, at page 603, which I'd like to understand. He says something which, on its face, might support your argument, but I'm just wondering how it's to be construed. He says, upon the principle that juris sanguinis nunquam prescribitur, I'm of opinion that unless some other person had been served as nearest and lawful heir male of the body of the last legitimate Lord Macdonald, the third Lord Macdonald, the pursuer is entitled to take the appropriate steps to establish his propinquity. So it's that proviso that might support your argument, but I'm not sure that I understand it, or how it's to be reconciled with the Dunbar of Kilconny case.
Thank you, my lord. My lord, if I can come back to Lord Mance's question for a moment. Of course, the Dunbar-Kilconny case was about the effect of the Legitimacy Acts. And what was said about the missing heir cases was, well, this isn't a missing heir case. But the missing heir cases were not actually examined in the Dunbar case.
It seems to me the Dunbar case is a pretty special case. It's to deal with an exceptional situation, and they've invented a pragmatic rule.
Yes, although, as I say, I certainly do expect to come back to it, and just as my learned friend relies on it, I rely on it for what I say should be taken from it, which is rather different. Lord, sticking for the moment to the English cases, we come on to the Banbury peerage case, which everybody agrees is one of great importance, and that is in the first authorities bundle at page 541. In fact, it's the first divider in that authority. Now, the Banbury case is probably best known for the questions which the Committee for Privileges referred to the judges and to the answers which were given by the judges. We have set those out in our case, and I don't propose to go through them. But what I intend to do is to draw the Board's attention to what happened when the matter actually came before the Committee for Privileges. And this is another, I'm afraid, very lengthy extract from Nicholas. But the second divider, but we don't need to look, you'll be glad to hear it, by any means all of it, because the report of the judgments starts at page 712, internal 459.
Sorry.
We had a law report,
Yes.
which you first referred to, and are you now taking us to Nicholas's account of it?
Well, my lord, my lady, the law report that we have deals with the answers of the judges. This is the best account that we've been able to find of the speeches which were made in the Committee for Privileges.
So the other was the judges, the opinion of the judges considered by the House of Lords?
Yes.
Or the committee, rather?
Yes.
Sorry, can we just get the
That's
page?
459. You mean it's on page 712 of the
Yes.
bundle?
Yeah. Yes, my lord.
Thank you.
Now, 4 members of the Committee for Privileges delivered speeches. One of those, Lord Erskine, was the great supporter of the claimant.
Yes.
And perhaps just,
Did they all agree or not?
no, they didn't agree.
Gathered that might
And
be.
ultimately, the Committee for Privileges divided, but only 4 members of the committee delivered speeches.
Right. And was Lord Erskine in the majority or not?
No, he was in the minority.
The footnote suggests that the writer is strongly partisan for one or the other side.
The writer is partisan for Lord Erskine.
Footnote 4.
Yes. There's no, my lord, I would invite you to ignore the footnotes.
But this is the author of the book
This is the author of the book,
commenting. Mr. Nicholas.
Yes.
He's commenting in 1936.
1836.
18. Oh, sorry, it says 1936.
Sir Harris Nicholas.
No, it says 1836 in the index. I was a bit surprised.
But
Right, thank you.
his comments are indeed partisan. But
Anyway, who are we reading?
We
Lord
don't do
Rees?
it that way these days, do we?
no.
That's more fun, yes.
Who are we reading? Lord Reesdale?
Well, we're going to be looking at a brief passage from Lord Reedsdale, which we can find at 739.
Was this the Lord Reedsdale who was Lord Chancellor of Northern Ireland?
Of
Ireland?
I believe so.
That's a very cautious answer, thank you.
Well, he was certainly a Lord Reedsdale who held high judicial office. He was not, as sometimes happened in those days, just a member of the House of Lords exercising his right to speak in the committee.
And he's going to be in the majority, is he?
He is going to be in the majority.
Jolly good.
But there's just one aspect of his speech which I want to refer to, which is at page 739.
Right.
At the top, where he says, independent of any other part of the case, I think lapse of time a sufficient ground for rejecting this claim. And I am persuaded that it is as important to hold lapse of time on a question of peerage to afford the same objection to a claim of peerage as it does to a claim of any other description.
Which page are you reading?
I'm sorry, it's page 739 in the bundle, internal page 486.
This is 1813.
Yes.
I ought to know, Mr. Scott, but I expect you do. Were there limitation acts already, or simply the practice of the Court of Chancery in relation to the barring of old claims?
My lord, I'm afraid I don't know that. We'll have that by tomorrow.
How long was the lapse of time in this case?
It was well over 100 years.
That's what I thought.
But this is all in terms of a presumption. If you look at the previous page, the word presumption appears repeatedly, start near the top.
My lord, all that part of the speech is, but he makes it very clear with his opening words for this section, independent of any other
No,
part
that's
of
not the opening words of the section. The opening words of the section are back where I started. And
they're on top of, it's all a quotation from someone. Who's it a quotation? Is it, this is Lord Reedsdale speaking.
This is Lord Reedsdale speaking.
The context in which he's saying what you rely on is that there is a strong presumption against the claim in certain circumstances, one of them lapse of time.
And he refers to a statute of limitation, incidentally, but not applying.
Oh, well done.
My Lord, I respectfully suggest that that's not the right reading, that he's moved on from the presumption and he's making a separate point, and that the words independent of any other part of the case can only mean that.
No, he comes back. Non-claim constitutes a strong ground of presumption against the right. Underneath the word independent, about 10 lines down. So it's all part of the same passage.
Yeah.
My Lord, I'm sorry, I haven't highlighted that.
But about 12 or 10 lines down,
Page.
on page 739, under the words independent of any other part, he says, but where the right is entire and no disability can be suggested, non-claim constitutes a strong ground of presumption against the right that the right was barred or the claim not well-founded, although the objection to the claim may not, in consequence of the lapse of time, be clearly shown. So it's all part of the same paragraph, and it's all part of the discussion of what he describes as a strong presumption against the claim arising from delay.
And the last sentence of that, lapse of time coupled with previous proceeding,
Yeah.
being conclusive against the claim, suggests that lapse of time on its own may not be.
Well, my Lord, let's move on to see what Lord Ellenborough says.
Well, the House has held conclusively against the claim in 1727. Who can question what he'd have thought in 1811?
Well, my Lord,
Seems a far cry from...
Well, it's evidential. It looks as if it's evidential.
to try to give even a potted history of this case would take all afternoon.
Well, I see that.
And the question of what had been conclusively decided earlier was itself hotly contested. So, with great respect, it's not quite as simple as that.
Okay, do we get more help from Lord Ellenborough?
Well, yes, we do. And for that, we go to page 741, just the next page.
I like the first sentence, as Lord Mance points out, of Lord Ellenborough's judgment.
Yes. Yes. Absolutely. But at the top of page, internal page 488, page 741, we have this: the descendant of Nicholas Vaux is now endeavouring, after a feverish period of 180 years, to establish the legitimacy of his ancestor. The sole question before the House is whether Nicholas was the legitimate son of William Earl of Banbury. Right. It has been urged with great force by a noble and learned Lord Reedsdale that the very remote date of the cause of the discussion is alone fatal to the claim.
Right, you have that, yes.
So the case is of such a size and of so peculiar a nature that the technical rules followed in other courts of law should be applied to it with caution. Yet in the absence of precedents, I am disposed to adopt the sort of reasoning upon which all statutes of limitation are founded. Now, although the period...
There's footnote.
My Lord, the footnotes are...
I do say we're supposed to disregard the footnotes, but...
Well, for a moment's amusement, they're well worth reading. But I don't think that they actually advance the argument much. It's certainly not anything I rely on. I think it's right to say that Sir Harris Nicholas took an extremely conservative view of the law of adultery and bastardy.
What is a conservative view of that?
Well, he basically didn't believe that I mean, he was doubtful whether what had been known as the doctrine of ex quattuor maria should ever have been disregarded. In other words, the former doctrine, which held that unless it could be shown that the husband had been outside the realm throughout the period of the pregnancy and for some time before, then the child was ineluctably legitimate. Now, the law had moved on from that, but he accepts that with ill grace, and he is certainly very reluctant to accept that non-access could be proved, or the methods by which it could be proved. These are not points which arise in the present reference.
Yeah. At the end of the day, we're more interested in what Lord Ellenborough had to say.
Well, my Lord, yes. So far as Lord Ellenborough is concerned, the particular point that I rely on, obviously, is that both Lord Reedsdale and Lord Ellenborough regard the period of time as sufficient to put an end to the claim. And although it's right to say that we're dealing with a period of 180 years, as against that, throughout that period, the son and his descendants had been pursuing the claim. So in that respect, although the period of time in the present reference is shorter, we are a fortiori in that their claim has only been raised very recently.
Is Lord Ellenborough's disagreeing with Lord Redesdale's conclusion, is he?
No, he's not, my lord. He's
he
agreeing
doesn't.
with it in a slightly roundabout way.
741 seems to make the point that the presumptions being presumptions are always rebuttable.
Yes.
And he concludes on 742 that Nicholas was illegitimate. Well, it appears to me, and I trust, on an attentive examination of the proceedings in 1661, it will appear to all the House that the committee has little doubt that Nicholas was illegitimate.
Yes, my lord, that's right.
So but
felt themselves bound by no rule of law until then acted upon. In other words, to reach a contrary conclusion.
It would just help to have a statement of who the judges were and who decided which way.
Well, my lord, I'm trying to take you through it. So far, we have Lord Redesdale and Lord Ellenborough, who decide against the claim.
Yeah.
We then have Lord Erskine, who has
Can
always...
we have this on one sheet of paper, do you think, overnight?
Yes, my lord, I
Thank you
do.
very much.
So Ellenborough joins him, and what about the others ones? Just summarise.
Erskine is is in favour of the claim, so he takes a totally different line. And then the fourth member is Lord Eldon, and he starts, his speech starts at page 767. He does not express a view one way or another on what I'll call the limitation point.
Yes.
But what he says at the bottom of page 767 is this: upon an accurate review of the evidence, it would seem that from the death of the Earl of Banbury in 1632 until 1661, nothing had transpired to make it probable that Nicholas Vaux had a right to the earldom. Your lordships must therefore place yourselves as if you stood in this house in 1661. Had we then been called upon for our opinion, I think that it would have been impossible for any of us to have declared Nicholas to be the son of the Earl of Banbury. So going back to Lord Mance's point, yes, the majority, both of those who spoke by 3-1 and of the committee by, I think, 21-13, held against the claim and held that Nicholas was illegitimate. But the issue which now arises, and the submission which I make, is that of the 3 members of the committee who spoke against the claim, 2 of them rested their position in the alternative upon a lapse of time.
The lapse of time, did they explain what it was? It was 180 years, was it?
Yes.
And was that saying 180 years simply that, or was it some event, or was it combination, or was it simply lapse of time without further specification?
Well, my lord,
Because if it's 180 years, one might say, well, they perhaps were saying 100 years was cut-off date, which wouldn't suit you. Or they might have been saying 50 years, or they might have been saying the death of the allegedly illegitimate.
They don't say that, my lord.
No.
They don't. This is all we have.
Fair enough.
And as to what had gone on in the past 180 years, well, that is why this section of the bundle is so thick, because it takes this long to tell the story. It is really quite incredibly convoluted. But we will try and do our best to fit it onto a single sheet of paper.
Mr. Scott.
But I rely also on what Lord Eldon says, that you looked at it as the position would have been in 1661.
Well, I think Mr. Guthrie would agree with that. Or might agree with that.
It all depends what you mean by looking at it in
Yes.
1661. Do you mean knowing only what was generally known in 1661?
Well, what he appears to be saying is looking at the law as it was. Yes, as both at the law and the facts as they would have appeared in 1661.
They would have appeared, or as we now know they were.
Well, of course, there's always a...
Would it have made a difference in that case?
It's, my lord, I can't point to anything which specifically says that it would.
Thank you. Yeah. Anything else you want to say about the Banbury case?
My lord, no. So, my lord, I was at this point going to refer to two of the Scottish cases which appear in the historical sequence at this time, but I will pass over those. Very briefly...
Passing over those because you're coming to the Scottish cases.
Because we're coming back to the Scottish cases in January. After the Banbury case, and referring now to the answers of the judges to the questions as set in our case, then the law of adultery bastardy was clear and remained much the same until well into the 20th century. And the law, as we've summarised it in our case, was that if you could show by circumstantial evidence or any admissible evidence that there had not been a possibility of access, i.e. of marital sexual intercourse, then you could show that the child in question was legitimate. But nothing less than that would do. And quite specifically, you could not rely on the fact, if it was a fact, or you could not rely on an allegation that that a wife had committed adultery. Or indeed, even if it had not been adultery, because if the conception had taken place before the marriage, if the child was born within the marriage, you were not able to allege that the child was the child of another person because of because of established intercourse with another person. That was simply a route which could not be travelled.
What, never, or only when it fell short of providing sufficient geographical separation between husband and wife to have made it impossible?
No, that was admissible because that was evidence which showed to take the extreme example, if the husband had been abroad for 5 years, even in the oldest times, that was sufficient to show that access, as it was delicately known, could not have taken place.
Yes.
As the law developed in the Banbury case, then others more wider circumstantial evidence became admissible.
I was going to say, there's a lot of stuff in the Banbury case that's got...
Quite.
I mean, that was the law. They were making a mountain out of a molehill, weren't they, in Banbury?
One might think so, my lord.
And Lord Ellenborough could have been doing his other things.
Well, I mean, among other things in the Banbury case, they're looking at the way the possible father, the husband, behaved towards the children.
Yes.
The children, aren't they?
They are.
A father's heart yearns for his children, but this father made no provision whatever for them and rather denied them.
Behaved as if he had no children.
Yes.
And indeed...
Wouldn't have done what he did if he had thought he had children.
And settled his estates on a nephew, which he had no legal right to do if he had an heir.
Quite.
If it was, you're virtually saying it was an irrebuttable presumption, unless you could prove lack of access, that if a man's wife conceived a child, it was his child. Is that what you're saying? There was an irrebuttable presumption unless you could prove lack of access.
Yes.
Where do we see that most clearly stated?
Well, my lord, we can perhaps come on and we can look
But
at...
as I say, I just don't understand if that's right. If that was the law at the time they decided the Purbeck, the case we were just looking at. I don't understand Banbury case. I don't understand why it wasn't.
Well, my lord, I think
it takes so many pages.
It's put very clearly, I think, in the next case that
Okay.
I was going to come to.
Page 744, Lord Ellenborough, seems to be saying exactly what my lords have said, that when applying the reason of man to the conduct of man, your lordships must be governed by the induction which reason suggests. If this rule is observed on the present occasion, it must lead to the result that it's morally impossible that the Earl of Banbury should be the father from whose loins either son issued. And then he cites Corbyn, where, although the husband and wife were living under the same roof and had full opportunities of intercourse, yet the child was declared illegitimate.
Yeah. That is, of course, separate from your, what I will call in inverted commas, limitation point.
Yes.
Or your posthumous bastardisation point.
Yes.
Because what Lord Ellenborough and indeed Lord Eldon are looking at is the situation as at the time,
Right.
1661.
Yeah.
My lord, that is right. Thank you. Yes, the effect of the Banbury case was to widen the categories of evidence which could be introduced, so as to make it possible to introduce evidence of this kind, of the father rejecting the son and all these other matters. But what was still absolutely inadmissible was evidence of the wife's adultery, or reliance on the wife's adultery, so as to try to show illegitimacy.
Yeah. So you could prove it other ways, although the inevitable conclusion was that she committed adultery. Yeah.
Well, obviously, if you find the child illegitimate, then that necessarily follows, yes.
Well, it's more, isn't it, that evidence that she was sleeping with someone else wasn't enough.
The fact that she was not living with her husband was admissible, but it was not so much the fact that she was living with somebody else as that she wasn't living with the husband.
Yeah. Yes, another way of saying the same thing. Yeah.
Okay, you wanted to take us now to a Scots case?
No, my lord, I'm steering clear of those.
Sorry, I thought the next case.
No, I'm going to go to a Welsh case, in fact,
Fine.
which is still in Bundle 1 at page 1164.
Cases are terrific.
Yep. Quite well. Yep.
And yes, this is the Lord Chancellor. I'm afraid the identity of the Lord Chancellor isn't given, and I haven't looked that up. But I think we needn't go into the facts really at all. But on page 1195, internal 396, there's this observation on the third paragraph. If after the birth of a child whose legitimacy is questioned, the husband and wife had acknowledged the child as legitimate, such recognition would beyond all doubt be received as strong evidence of the legitimacy. But if so, evidence of their having repudiated the child as illegitimate must be receivable to disprove the legitimacy. And then about 10 lines lower down, as this is, I suggest, is fairly definitive statement of the law at this period. If sexual intercourse be proved, that is, if the jury or the judge trying the question of fact be satisfied that sexual intercourse took place between the husband and wife at the time of the child being conceived, the law will not permit an inquiry whether the husband or some other man was more likely to be the father of the child.
Sorry, which page was
I'm sorry, my lord, it's page 1195, internal 396.
Yes, I've got it.
Well, that's moved on a long way from you can't challenge paternity unless you can prove non-access by the husband.
Well, my lady,
by external means. It's moved on a long, long way, hasn't it?
Yes, but it still leaves in the position, which is all that I need to rely on, is that if access is proved, then you can't go beyond that. And so the relevance of the fact that the wife may be living with another man, all these other matters, are circumstantial evidence which are admissible on the question of access. But once access is established, that is final.
This is public policy, that we should shut our eyes to anything else. Is it? I mean, the rules of evidence are conditioned by the social and scientific circumstances of the time, I would have thought.
Well, my lord, of course, but one very important point which I'm going to be coming on to is the public policy of which time, so far as somebody is born in 1903 and died in 1961 is concerned.
It brings you back, you say, to the point that House of Lords thought it right to judge it as at the earlier date.
Exactly.
In the Banbury case.
Exactly. And then to bring us into the 20th century, at page 1060,
But page 396 makes it quite clear that these are all simply rules of evidence. It all depends upon the factual situation. See the last paragraph of page 396. Really.
well, my lord, they're rules of evidence, but they're rules of evidence which condition the entire approach.
Will you say that they're rules of evidence grounded in a deliberate policy
Yes.
to shut out
Well, you
inquiry?
wouldn't guess that from page 396.
No. Well,
I'm sorry, my lord, I've closed it. Let me go back to it.
What's the...
Sorry, 1195.
But we're probably talking a lot of different policies here.
yeah.
I mean, most of this is about the severe disabilities of illegitimacy if a child was bastardized,
Yes.
to use the language they used, and also the severe disabilities then visited upon the mother.
Yes.
So it was greatly to the benefit of both mother and child to have these rules of evidence that made it very difficult to prove that a child born to a married woman was not her husband's child. But the question always was the child the husband's child? That was always the question.
My lady, that was the question, but the rules of evidence were so strict.
Yes, we've accepted that, but
Yes.
what we're putting to you is that these are rules of evidence.
Yes, my lady,
Don't change what the question is.
No, my lady, I accept that.
But you say
I'd write that down, Mr. Guthrie, if I were you.
you say they're rules of evidence which have to be, and principles that have to be applied not by reference to standards today, but by reference to the standards that would have been applied if the challenge had taken place when it could and should have taken place in
Yes.
a perfect world.
Exactly.
And therefore what Lord Cottenham said in Morris and Davis may tell us what the law was in 1836. But if it tells... Yes, but we need to look at the law which was in place at the relevant time for our purposes.
Well, Lord, I'm just coming on to that, and the next case
We're going
is
to
one
take us to a case
which was
for that.
decided by chance in the year when Sir Norman, the 9th Baronet, was born, 1903.
Very good.
And that's at page 1060.
Oh, yes, you said. Yes.
And unlike the others, it's a mercifully short report. And the context in which it arose was that the respondent took out a summons to vary the order as to custody on the ground that before the petition was filed, an agreement had been reached as between herself and the petitioner that the child should remain with her. But anyway, the judgment stands by itself. The law says that what has to be proved is that the husband did not have intercourse which might have led to the birth of the child. It does not allow the fact that another person had intercourse with the wife to be a material consideration. That is, I think, a proposition of the utmost importance in cases such as this. It was recognised in the opinion of the judges who were called in to assist the House of Lords in the Banbury peerage case. In Cope and Cope, Baron Alderson, in summing up, said, "If once you are satisfied that the husband had sexual intercourse with the wife, the presumption of legitimacy is not to be rebutted by its being shown that other men also had sexual intercourse with the woman. The law will not, under such circumstances, allow a balance of the evidence as to who is most likely to have been the father." And then we go back to Sir Harris Nicholas, who said this: "Though widely different from the law in year 1632, when the first Earl of Banbury died, and for more than a century afterwards, with respect to the nature and extent of evidence which is admissible to prove that the husband is not the father of his wife's child, still the principle upon which these opinions were founded is precisely that of the old law. Sexual intercourse between man and wife must be presumed, and nothing except evidence that the husband did not have such intercourse at the period of conception can illegitimize a child born in wedlock. If the husband could, from circumstances of time, place, and health, have had nuptial intercourse with his wife, and there be no evidence to prove that he did not have such intercourse, he must be considered the father of her child, even if she had committed adultery with 1, 2, or 20 other men. So, while I accept that Sir Harris Nicholas took a possibly somewhat conservative view of the law, here we have him being cited 80 years after his textbook was written, and this was the state of the law at the time when Sir Norman was born.
State of the law of evidence.
The law of evidence, my lord, yes.
This appears to be a bit of Sir Harry Nicholas that we don't appear to have. Is that right?
Well, my lord, I thought that it would carry more authority to present it cited in a judgment.
But I mean, I don't know whether he deals at this part of his textbook with the Banbury case, which he is so indignant about, but I'm not sure what he says here is consistent, is it, with the Banbury case?
My lord, I suggest it is.
Yes, I
Banbury cases.
And it
It does
certainly,
refer to the Banbury case.
in any event, nearly 100 years after the Banbury case, this was adopted by the President of the Probate Division.
So do we have page 186 of the treatise?
Page 100 and...
Well, the footnote 1 on page
My lord,
1062.
we omitted to bring our copy of the book,
But perhaps we could have a...
but we'll have it tomorrow.
Yeah. Is there any other authority which cites that and approves that passage or follows this case in precisely those words? Because it's strong language.
Certainly none that we put in the bundle.
Surely not a... Where on today? Oh. It would still be true that the mere fact that you were sleeping...
What the President says seems to, I mean, he cites on NS 1061 the opinion of the judges in the Banbury Peerage case in 1811, and the passage that he's citing does support what he's said. But you took us to the Committee of Privileges, who seem to have looked at the matter more widely.
Well, my lord, of course I'm very happy to go back to that. I moved over it because that is all set out in our case, but I'm very happy to take you back to it.
He appears to cite it in a different report. Well, no, it is a... We've got the original report, have we?
Yes.
Yes, we have.
It's on
Yes.
NS 543.
Right. Yes.
I wasn't planning to take my lords to the Russell and Russell decision, partly because it's not directly in point and partly because it's very well known anyway. But it is, I would suggest, it shows clearly that the law in relation to the presumption of legitimacy had not changed in the 20 years which passed between Gordon and Gordon and that decision of the House of Lords.
Right.
Was this one? Yeah. Well, perhaps we should just briefly look at Russell. What page is it?
1373. The first page is 1363.
If we can go to page 1363.
The next tab. Tab 27.
1363.
It's at the very back of the first bundle for those who are
Yes, thank
using
you.
hard copies.
Thank you.
Plus 2 tabs.
and I think we need only look at a small part of it. But if we can go to 1373, speech of the Earl of Birkenhead. This is dealing with what I'll call the subsidiary rule of evidence about spouses not being allowed to give evidence, but that rule was in support of the underlying policy. So the fact that it was so resoundingly upheld in this case demonstrates in our submission that the underlying rule of policy was still alive and well at this time.
Rule founded on decency, morality, and policy.
Yes.
Not it appears truth.
I'm sorry, my lord.
Not it appears truth.
Well, there are other situations where there are countervailing points in relation to truth, such as limitation, estoppel, where there are factors which are more important than the possible truth.
Deals with truth. You do with it.
Yeah.
And the reason given is that it would tend, if given, to bastardize the issue and to invade the very special sanctity inherent in the conjugal relation.
Yes.
That's the policy.
Yes, and also if we look at 1375, the last sentence in the second paragraph, what Lord Mansfield meant was that a deeply seated domestic and social policy, rendering it unbecoming and indecorous that such evidence should be received from such a source upon such an issue and with such a possible result.
But the source is the husband and wife, isn't it?
Yes.
Especially the mother, who seems to be treated as, who is treated as the offending party.
My lord, that's all right. I mean, I fully accept that this is dealing with a subsidiary point of evidence in relation to a presumption. But nevertheless, it is, as I say, a demonstration that the presumption was itself alive and well at this time.
Yes, I understand that.
And indeed, there is nothing to suggest that it changed thereafter until we come on, as we shall in a moment, to the Family Law Reform Act 1969.
Oh, and the cases that were decided before that Act came into force.
And sorry, Lady, which?
I believe that Rias was decided before that Act came into force.
Yes. Well, I was going to turn to S and McSee.
That's the case I'm talking about.
Yes.
Is that where we go to next?
That's where we go to next, and that is at page 1435.
Right, so we go to the next bundle. Right, thank you.
And we have, of course, by now passed on to a time after the death of Sir Norman.
Yes.
Now, this was a case about whether the court had power to order blood tests. So, again, not directly relevant to the present issue, but the leading speech was that of Lord Reed. And he cites, at the bottom of page 1451, Section 26 of the Family Law Reform Act 1969. So I believe the history of this case was that the judgments under appeal had been heard before the Act came into force, but by the time it reached the House of Lords, the Act was in force. So he was able to reflect on the Act, even though it was not directly applicable to the case. But can we perhaps look at Section 26? Any presumption of law as to the legitimacy or illegitimacy of any person may, in any civil proceedings, be rebutted by evidence which shows that it is more probable than not that that person is illegitimate or legitimate, as the case may be, and it shall not be necessary to prove that fact beyond reasonable doubt in order to rebut the presumption. So, a number of points. First of all, what it deals with primarily is the standard of proof. It reduces the standard of proof from beyond reasonable doubt to balance of probabilities. But secondly, and very importantly, it says it uses the present tense, evidence which shows that it is more probable than not that that person is illegitimate or legitimate. There would have been no means at the time when this Act was passed, following on as it did from a Law Commission report, for blood tests to be used to establish the legitimacy or illegitimacy of someone who is dead. And in our submission, it is quite clear that when this was enacted, Parliament had no intention or thought that it would have a retrospective effect.
It would be interesting to know whether the Law Commission report had anything to say about presumptions in 1969 or shortly before.
Will have done.
Well, my Lord, I do have a copy of that, which I can happily hand in. It doesn't take matters much further. What it says, in effect, is, as Lord Reid goes on to say, that this is a reflection of changing social attitudes.
No, what would be interesting to know is what it said that the law was before this Act came into force. But it may not throw light on the precise point we have. If it doesn't, don't.
Well, I don't think it throws very much light on it.
Okay, thank you. Yeah, sorry, you were going to read on. I interrupted you.
Well, my Lord, yes, but I do want to come back to the effect of Section 26. But at the moment I flag it up. But let's continue with the judgment now.
Yes.
Over the page, Lord Reid says, that means that the presumption of legitimacy now merely determines the onus of proof.
Yeah.
And then at the bottom of page 1453, he deals with the policy aspect. He says, in former times, it was plainly in the child's interest to have a finding of legitimacy, even where the presumption of legitimacy had been used to overcome evidence which without it would have pointed the other way. An illegitimate child was not only deprived of the financial advantage of legitimacy, but in most circles of society, other than those considered disreputable, it carried through its life a stigma which made it a second-class citizen. But now modern legislation has removed almost all the financial disadvantages of legitimacy, and it's become difficult to foretell how grave a handicap the stigma of illegitimacy will prove to be in later life.
He was, of course, entirely wrong in that statement about remove the financial disadvantages of illegitimacy.
Yes, absolutely.
He was thinking only of inheritance. He wasn't thinking of maintenance.
And
many other
Schedule
things.
1 of the Children Act was in the back of anybody's mind. But
Absolutely.
Relief to know even Lord Reid could go on.
But he probably didn't tell that.
But in the next paragraph, he goes on to say, taking all these matters into account, I accept the view that on average it is still a considerable disadvantage to be illegitimate. But I doubt whether, again, on average, this disadvantage would be greatly diminished by a decision in favour of legitimacy seen to have been based on inadequate evidence after refusal to allow a blood test. I think that the final abolition of the old strong presumption of legitimacy by Section 26 of the Act of 1969 shows that in the view of Parliament, public policy no longer requires that special protection should be given by the law to the status of legitimacy. And that, although he doesn't refer to the Law Commission report, but that reflects the view of the Law Commission report which led to the Act.
It probably, the Act reflected another report. Not only the Law Commission report, that was a very small part of it. The rest of the Act was allowing illegitimate issue to inherit. That was the major part of the 69 Act.
Yes.
And that was the result of somebody else's report. Was it Russell? Anyway, I'm trying to remember.
Was it Lord Justice Sachs, possibly?
No, I don't think it was Sachs. Sachs was the age of majority.
Late age.
Which was also in that
Late
Act.
age majority.
Leahy was age of majority. Well, I don't think it was Sachs then. Anyway, we'll look it all up.
I think.
You're right about Leahy.
So, of course, the point I make is that the Act, and in particular Section 26, reflected changing social mores. It would not have been technologically possible to apply the use of blood tests to determine the legitimacy of somebody who was already dead, and that the Act was certainly never intended to have any retrospective effect. In this sense, it had retrospective effect in the sense that it applied to tests conducted on any person living at the date when it came into force. But it was not intended to apply to anyone who was dead at the date when it came into force.
You get that from what? Just what do you get that construction from?
I get that, first of all, from the technological context in which it was passed, in which blood tests were possible but could only demonstrate the relationship between living people.
Well, I mean, you might have either blood or the results of a blood test surviving the person who had donated the blood.
Well, my lord, with respect, even if that is theoretically possible, it is so vanishingly unlikely that I submit that cannot be what Parliament could possibly have had in mind.
Wasn't the Moynihan case an example of that sort of thing?
The Moynihan case was somewhat later than this.
Yeah. No, but I mean, it's an example of somebody who actually had left a sample which was available for analysis after he died.
Yes, but he had the test made when he was alive. So, yes, I mean, your lordship is right to that extent. But, of course, in the Moynihan case, it was the legitimacy of living individuals which was at stake. But going back to Lord Mance, the starting point for my saying it has no retrospective effect is simply the language of the section, that it could have said, more probable or not, that a person is or was illegitimate or legitimate, but it didn't do so. And I suggest the obvious reason it didn't do so is because it never crossed anybody's mind that it might be applied in that way.
It is correct, isn't it? You'll tell me if I'm wrong, that the blood tests that were ordered at first instance and upheld in appeal in S&S were ordered long before the Family Law Reform Act had hit the statute book.
Yes, they were, but, well, a couple of years before. Well, in fact, if we go back to page 1438, which sets out the facts of S&S, the last paragraph, the judge made the order on January 22nd, 1969. So, in fact, not very long before, maybe a year before.
Yeah.
The same year the Act was
But the
passed.
facts were a lot earlier, weren't they? That's what I was going on.
Yes.
I mean, it's just interesting that
Yes.
the judge obviously thought it was an appropriate thing to do,
Yes,
even though the Family Law Reform Act had not come in.
yes.
Was anything said in the Court of I'm sorry, I beg your pardon. Was anything said in the Court of Appeal in the two cases relevant for our purposes about the law in these two cases, S and McC and W&W?
I hesitate to interrupt, but there is a reference to the use of such evidence on page 1439 at letter E.
Yes, thank you.
Yes.
I think the learned friend in his response refers to the use of blood tests in California in a case concerning Charlie Chaplin.
Right.
But the power that was used before the 1969 Act was essentially the paternal powers of the High Court, wasn't it? To direct, in the interests of the child, that the child supply a sample of blood.
Yes.
You couldn't direct anybody else to, I don't think.
think, could you?
That's what seems to be recorded here, certainly in Scotland.
No, I think that's correct. That was what the 69 Act was about.
And the 69 Act provided the power to direct adults.
Yeah, I mean, that's the passage that Mr. Guthrie drew to our attention at 28E. So 1439E says that, no power to order an adult to take a blood
Yeah.
test.
Yes, thank you.
But the point I was getting at was that it had been done. I mean, people had agreed. It had been done. And before the Act came into force, and this is in flat contradiction of any notion that you can't introduce evidence other than non-access evidence.
Yeah.
Evidence to show that the product of whatever was going on is not the product of this particular man, but maybe some other. So it's an indication that the thinking had moved on by the time we got to the 60s at the very latest.
Yes.
But basically, you take your stand that we have to apply it at the earlier stage,
Yes.
a reference to the approach of the law at that time.
Yes.
Have you got any authority, or can you think of any other example of a case where, when the laws of evidence change, we conduct trials under the old laws?
I suppose that most cases it wouldn't be particularly relevant because there'll be limitation issues. But if there's no limitation point, then you can go back far into the mists of time. I understand that it would be arguable that you should apply the principles applicable at the relevant time rather than now. Whereas most other cases you don't get such stale claims because you've got limitation.
But evidence is normally regarded as a matter of procedure.
Yeah. Well, my lord, it is. And
Changes.
The question is what today's procedures should be.
But to
One
deal
would
with,
surely apply the rules of evidence for today.
well, my lord, if we're dealing with cases of today, yes. But if we're dealing with cases of...
Or if we're dealing with evidence today.
Well, my lord, that depends on the outcome. Because a law which can be procedural in one context can be substantive in another context.
And it may be procedural, but we still have to ask ourselves what rules of evidence should we apply today. So it begs the question to say that it's a question for today, because the answer may be we should, as a matter of procedural fairness, apply the evidence, or appropriateness, apply the evidence of the past. You say the question is who should have succeeded to the baronetcy at the time the 8th baronet succeeded. But Mr. Guthrie says the correct question is who should succeed, has succeeded 2 years ago.
Well,
when your client's father died. He says that's the right question.
well, my lord, I on his own case, I don't see how that can be right, and a number of your lordships put questions to him, which I think...
I think he accepted that his client's claim arose in 1968, not 2 years ago.
Yes, 61, I think.
61.
Is the logic of your case that, leaving aside rules of evidence, or such as we've seen, and assuming it's all a matter of presumption, actually DNA evidence ought to be totally inadmissible because it didn't exist in 1903?
Well, no, my lord, because it would be admissible by consent.
No, but if it's not by consent.
If it's not by consent, then, well, if it's not by consent, and if it's hard to see how it can come into existence. How is anybody going to have it if it's not by consent?
Are you talking about the consent as to its admissibility or consent as to whether it was taken?
I'm talking about consent as to whether it's used.
No, but Lord Mance's point, surely, is this. If we're to judge matters by a date in the past, more than 50 years ago, then by definition DNA evidence wouldn't be admissible because nobody knew about DNA evidence or had it, as it were, as evidence 50 years ago.
Well, no, because, my lord...
surely that's the logic of your position.
Well,
not
my lord,
necessarily
no.
a bad argument, but...
It isn't, because you might have a case where the parties, where everybody concerned was agreed that if there had been, quote unquote, a wrong turn in the lineage, then this should be corrected. And in those circumstances, the DNA evidence would be obtained
by
and could be
agreement,
used by
you can
consent.
do a lot of things, leaving aside that.
But leaving aside that, no, I would say that because the only way, if it's not done by consent, then what proper way is there for a claimant to have got hold of the DNA evidence?
yes, let's say he did get hold of it properly. You would still have to say that it's not admissible, surely, because your procedural argument is we apply the rules and approach that would have been adopted at the relevant date, which you say was...
Well, Lord, I
Perhaps you'd like to think about that over the adjournment.
Certainly, I do stand by my position that I cannot see how it could have been obtained properly other than by consent, but I will think about it. And I would also, if I may, like to come back to Lord Mance's point about and indeed Lord Clark's point about whether a change in the law is merely procedural, because we do have an extract from Cray's on legislation, which I will be relying on, to suggest that in some, that even a statutory provision which is prima facie procedural, if it has substantive effect on past events, will not be treated as retrospective for that purpose.
Thank you. That's a fair warning. Thank you, Mr. Scott. We'll resume then again at 10 o'clock tomorrow morning. Meanwhile, the court's now adjourned. Thank you very much.
Interesting.